mistake. Royce, founder of the Royce Law Firm, a business, tax, and corporate law firm with offices in Northern and Southern California. So today's webinar is going to be a little bit different than what we usually do. We have a guest speaker, Patrick Costello, who's with Vectis Law Group in Palo Alto. And Patrick is a bankruptcy lawyer, and he's going to give us a presentation today on bankruptcy issues, primarily for business lawyers. This presentation will be recorded on our website, Royce University, and will also be available for a podcast. So with that, Patrick, I'm going to go ahead and turn it over to you.
Thank you. Well, let me tell you just a little bit about myself. I've been practicing bankruptcy law for about 25 years. All of those years in the Bay Area, but really within the last 20 years, focusing on Silicon Valley and Silicon Valley companies. I am what I would call a company-centric bankruptcy attorney. That means I represent tend to focus on the distressed company and representing the board and the distressed company. Although every bankruptcy lawyer does kind of a little bit of both. So I represent buyers in bankruptcy, some creditors and various creditors and other constituencies. But my main focus is on the distressed companies. And what I'd like to do today is kind of go through some basics for the bankruptcy lawyer. We have actually two handouts. The first handout is what I hope to spend a very little time on, what I call the 3 things that any lawyer ought to know about bankruptcy to start out with. Then, to the extent that we move beyond that, I have another handout, which is called the pitfalls in transacting business with the distressed company, which really talks about various transaction scenarios for the business lawyer that raise bankruptcy issues. Sometimes you're not quite aware of the bankruptcy issue, and part of what I want to do is just highlight those concerns and what those risks are. So let me start out with the very basics, what I think the 3 things that any lawyer has to know about bankruptcy. And the 3 things are, very briefly, the automatic stay, claims bar dates, and then avoidance actions. Let's talk about the automatic stay first. So what happens when there is a bankruptcy petition filed, whether it's filed by the company or it's an involuntary filed by creditors against the company, there's an automatic stay. And the automatic stay stays a number of actions, but what we really have to focus on is, number 1, it stays any action to collect or enforce any pre-petition claim. So that, that covers basically any ongoing litigation, any collection on a debt, et cetera, et cetera. It also covers any action to actually, take possession of or control property of the estate. And that's very broad, and that's what we really have to be careful about. And what that will cover, for example, I think every lawyer has to know is that once the automatic stay is in place, you can't terminate any contract or other relationship you have with the debtor. You may not have to perform that, perform pursuant to that contract, but you can't terminate it. And that's kind of one of the things that's the area where the non-bankruptcy attorney and the business person really kind of typically don't appreciate. They think, well, if they filed bankruptcy, I'm going to terminate the relationship. You can't do that. That's going to be a violation of the stay. And the important thing to remember about that is that, number 1, it's not effective. The action is void. So the debtor can always come back and say the contract isn't terminated or the action you took isn't valid or effective. But more important is that the debtor can get sanctions and damages for violation of the stay. So that's one thing you want to be careful about. So as soon as your client tells you that the other party has filed for bankruptcy, you automatically have to kick in and say, okay, there's a bunch of things that we cannot do because of the automatic stay. And so we have to start, we have to step carefully and probably get advice as to whether you can, as to what you can do without violating the automatic stay.
Are you taking questions or no?
But yes,
Sure,
I'd like to do this kind of informally. I'd like a Q&A format. So as we go through, let's ask the questions as they come up.
So if you have a contract that requires you to, say, deliver goods or do something affirmative, spend money, do whatever pursuant to the contract, is the company obligated to do that?
The first thing is that consider it that the performance obligation is in suspension. You will get some debtors that, and I've represented a lot of large, actually contract manufacturing clients run into this issue all the time. They have a contract manufacturing relationship, and the debtor files and then wants them to continue to perform. And the answer is the debtor, an aggressive debtor will be aggressive and try and say that you have to continue to perform, but in reality is that you can't terminate it, but you don't have to perform it.
Okay.
So don't go. What you don't have to do is kind of go is dig a deeper hole in terms of your your credit and debt to this particular debtor. Typically, what will happen is you'll work out some arrangement where you might continue to perform as long as you're getting paid on a post-petition basis. You'll try and kind of freeze the pre-petition amount and go forward on a post-petition basis. But that's a negotiated solution. The key is don't terminate the agreement, but don't perform the agreement until you get some advice as to what you might actually have to perform and what you're entitled, the assurances that you're entitled to before you perform.
And you need the trustee's authorization of any negotiated?
That depends on the nature of the contract. Sometimes the most conservative approach is that whenever you're dealing with the debtor, you get court approval for the new relationship or the ongoing relationship. In truth, that ordinary course of business transactions, which a lot of these transactions will be, don't require any court approval. It's the out of the ordinary course of business transactions that require court approval. The risk is that if it is an out of ordinary course business transaction that would require court approval and you don't get it, you're at risk that the whole thing is undone and whatever goods or money or services that you provide.
The broadcast is now starting. All attendees are in listen-only mode.
Conservative approach is if you have any doubt as to whether it might require court approval, you insist on court approval before you go forward. Okay.
So a clause in a contract which says you may terminate the agreement if you go bankrupt, if there's an automatic stay, it will not be enforceable.
That provision is enforceable in any case.
So maybe a better clause would be if you do actually go bankrupt, then I want upfront payment for any obligations I have to perform.
No, it's actually any kind of provision that is going to be specifically key to bankruptcy is going to be what we call an ipso facto clause, and it will basically be ignored and written out of the contract. It will be ignored. What you want to do in certain circumstances is you want to be able to key your performance to your obligations, to the performance of the debtor. And you don't want to key it to just financial conditions or the filing of the bankruptcy. You want to have performance-related defaults and say, look, if you're not performing this, this, or this, I don't have to do this, this, or this, or I'm entitled to this, this, and this. But we want to get to performance-related defaults versus financial conditions, bankruptcy-related defaults, because those kinds of provisions will basically be written out of the contract. They're just ignored. Okay? So, and as we go through, we're leapfrogging ahead to a bunch of issues that we talk about when we get to various transactional structures. But I think it's best to do it in a Q&A format. So let's leave the automatic stay. So if you hear that your client's the party that your client is dealing with has filed bankruptcy, you know, okay, there are certain things that I can't do and I don't want my client to do. Let's take a breath, figure out what we want to do, what our obligations are, and how we go forward. But don't take any dramatic, don't give any notices until you're comfortable as to what the automatic stay prohibits you from doing. Okay, the next thing is claims bar date. Bankruptcy cases, whether they're Chapter 11 or Chapter 7, have claims bar dates. And what a claims bar date is that it is the court sets a date that if you have a claim against the debtor and you want to receive any distribution or be entitled to receive any distribution on account of your claim or get paid through the bankruptcy case, you have to file a proof of claim with the court, or in these large cases, you actually file with the claims agent. And if you don't, then you're basically ignored. You're not entitled to any distribution. The one thing you just have to know is that as soon as your client says that I'm dealing with someone who has just filed bankruptcy, you go, okay, somebody's got to worry about a claims bar date. The easiest and most common malpractice is that the claims bar date is missed and the proof of claim isn't filed. And the courts are fairly rigorous in enforcing claims bar dates. It's very hard to kind of explain or justify it by the excusable neglect that you failed to meet the claims bar date. You want to be alert to that and know what that bar date is. Now, the fact that there's a claims bar date, there are certain, doesn't mean that you automatically file a proof of claim. There are certain jurisdictional consequences and implications to filing of a proof of claim. That in certain situations, if you don't want to be subject and you have a matter that you know is going to be litigated and you don't want litigated in bankruptcy court, you may not file a proof of claim. Because the filing of the proof of claim is a consent to personal jurisdiction. And there's the issue of whether you have subject matter jurisdiction and whether it should be in the bankruptcy court or not. But clearly the proof of claim is going to be a consent to personal jurisdiction, and it is probably a waiver of the right to a jury trial. And so if it's going to go forward in the bankruptcy court, you're going to go forward without a jury trial. And you have to weigh that's a litigation concern as to whether you want to preserve that or not. But the first thing you want to do is know what the bar date is and alert the client to that fact. And then the second is you can consider whether there are any consequences to filing the proof of claim or not.
I have a question. If you have intellectual property as collateral for a loan that you've given to a company that's gone bankrupt, when do you claim the IP? If the claims bar date is coming?
Well, number one, it presumes you were talking about a secured creditor.
Yeah.
You're a secured creditor.
Most of you have done all the things right as far as...
You've done all the things right. And you'll still file a proof of claim. But the real question is, when are you going to try and exercise your rights? And remember, the enforcement of your security interests is an action that is covered by the stay. So you're going to have to go get relief from stay in order to exercise those rights. So at a certain point, if you do want to foreclose and the debtor isn't resisting, you'll just get relief from stay in order to foreclose. But that's what you will do.
Okay.
The real question is whether you want to foreclose or you want to let the debtor sell it, the debtor or trustee sell it for you and just take the proceeds. If you want to end up owning it, you may still want the trustee to sell it, but sell it to you and credit your secured debt. But that's a whole range of issues for you as the secured party to consider. But your first rule is that, number one, you can't do it without relief from stay. And number two is you are going to want to file a proof of secured claim before the claim is taken.
Kind of detailed question. If the bankruptcy court, the reference is withdrawn from the bankruptcy court and the case ends up in district court and you have waived your jurisdiction, your right to jury trial by submitting to personal jurisdiction, do you get that jury trial right back if you end up in district court? Too detailed, you can talk to me later.
Yeah, no, I
take that offline.
I think that's fairly sophisticated.
Okay, move on.
My guess is that if you've gotten to the point that you've actually filed the proof of claim, you've got filed the proof of claim, you've got a problem in terms of your jury trial. If if you're doing a withdrawal and we're not a withdrawal of the reference and we don't have a proof of claim issue yet, the answer is you haven't waived your right.
Okay.
Okay. Okay. So that's our second issue. Just be aware that there are claims bar dates and that if you don't meet them or you don't schedule them, that you're out of luck in terms of execution. And it is the easiest way to commit malpractice because it's just kind of a tar baby. You're not bankruptcy attorneys, and you're saying, well, I'm not involved in the bankruptcy, but it's one of those things. As soon as you know about it, you have to tell the client at least that there is a bar date and they have to go look at it or it will come back. It's almost, you just touched the tar baby and it's hard to get away from. So just be alert to the claims bar date. The third is avoidance actions. And there are two kinds of avoidance actions. There are preferences and there are fraudulent conveyances. So let's talk about what a preference is. Now, there's a big whole definition as to what a preference is, but for you as business attorneys, there are two critical elements that you really have to think about. And they are, is that when you've got a transfer of property to the estate, okay, let's say what that is. What we're actually talking about is you're either transferring property, transferring money, and a transfer of property includes giving a security interest or perfecting a security interest. So anytime that you've got the debtor giving any property or encumbering it to property, you've got a potential transfer. And the second is that transfer is on account of the antecedent debt. And antecedent debt means it's pre-existing. It exists at the time of the transfer. It doesn't have to be liquidated. It doesn't have to be a note. It can be some even future contingent liability. But yeah, it's almost assumed that you're going to satisfy the antecedent debt requirement. Now there are a whole bunch of other requirements, but for you as business attorneys and saying, okay, trying to identify when have I got a bankruptcy risk, those are the two critical items you have to think about. I've got to transfer money or property, and I'm transferring it on account of an existing debt. Go ahead.
Let me just flesh out that. So a contingent unknown liability. So let's a doctor.
A what?
Let's say, for example, a doctor who may or may not have committed malpractice antecedents. Okay.
Right.
There's a potential claim in the future. But nobody has made it. Nobody has notified this doctor that they've committed malpractice. How does that fit?
Could you repeat the question, maybe, just so we get it on the record?
Yeah, the question is that we've got some debt. It's contingent. It's unliquidated. Say, like a doctor, some potential, say, malpractice liability is what we're talking about. And how does that play out?
So the doctor currently doesn't know anything about this potential claim.
Right. But our question is now that will qualify as an antecedent debt. think of the antecedent debt is liability. Whether the liability is liquidated, contingent, it's in a note, it's documented, undocumented, it's still going to be antecedent debt.
So the events occur
Exactly.
prior.
Yes.
The event that gave rise to the debt.
Yes. Correct. Now the question is, what transfer are you going to have that's on account of that?
Well, you might have you might have a doctor who's trying to transfer within his family.
Right. That's probably going to fall into our second kind of avoidance action of fraudulent conveyance. But I'm having a hard time anticipating where there's a transfer on account of the antecedent debt. And when I say on account of the antecedent debt, it's really in payment or satisfaction of the antecedent debt. So in our situation, your situation, you got a doctor, it's not like he's trying to transfer and pay that or satisfy that liability. He's trying to transfer to evade and put it and insulate his assets against that liability. That's going to flip us into the second one, the fraudulent conveyance. But the preference is where the payment is to pay that liability. And so the thing about how broad this is that a transfer is encumbering the assets. So it's either it's granting or even just perfecting a security interest. And so any time that you perfect a security interest on account of an existing debt. So when you go and decide that you're going to restructure debt and you're going to, on account of the restructured debt, and you're going to grant a security interest for the restructured debt, you've got a preference. Or you've got all the you've got the transfer and the antecedent debt, so you've got a potential preference. Okay, so and there are a bunch of other criteria, but I'm not going to worry you about those because what I want you to do is just start recognizing, boom, when do I have this potential, and why do I care about it? Well, number one, you care about it because you have to advise the client that there's potential. What happens in a preference is that if it is a preference, it can be avoided. It can be unwound. And so whatever transfer was made, whether it's the payment of money or the transfer of property, that property or that money can be brought back. So the reasons you care about it are, number one, you have to advise as to the risk. But number two, there are a lot of ways that we can restructure or revise the structure of a transaction that minimizes our preference exposure. That's what really the most of the materials on pitfalls and transacting business with a distressed company are about. Different scenarios and how you can restructure transactions to minimize or reduce the exposure. Sometimes there are situations that you can't eliminate the exposure, but there are a lot of ways to restructure that you can at least reduce or minimize the exposure.
What about, excuse me, unwinding a purchase and sale? I represented a vendor whose customer was like 100 days past due on paying the invoice. The customer had massive layoffs. They said, we have nobody to even ship this product. Take the product back and let's, eliminate the liability. The thought was the company might be forced into bankruptcy, but they had to get about $500,000 in debt off their books.
So this is a situation where, wait a minute, if the vendor is shipping, we have to be clear on who owes who money.
Okay, it's the customer that owes the vendor the money for goods that had been shipped 4 months ago.
Okay. And the customer is saying, I'm going to go,
I want to return this stuff. Will you take it back and write off the debt? Can we just unwind the transaction? Because we can't get funded if the first $500,000 is going out to you.
Right. And the issue is that that's clearly going to satisfy, that's going to satisfy the requirements. Because what's happening is customer owes client the money. That's the antecedent debt. he's going to return product. That's the transfer of property. So we've got our preference. What can we do about it? Well, clearly, just writing it off is not going to do it. But if customer ultimately files within the right time frame, the trustee can come back and say that I'm entitled to avoid or unwind the return of that product. And of course, the trustee is going to say, I really don't want the product back, thanks, but I want you to pay me the value of the product. Certainly that meets all the criteria for a preference. Our question is, what are we going to do to minimize that? Number one, you can take the product and hope that they don't file for 90 days. I guess there are some things we could do to try and minimize the preference exposure, but I'm not sure we can completely eliminate it. The fact that you're certainly giving out value. You're going to write it off your books, and that's value, but it's antecedent debt, and so it's not new value. What you could do, what you could do is, gee, if you said, I'll buy back my product, and kind of reverse the usual flow, that's new value for what you're paying for, but your clients don't want to do that. It doesn't make any sense. I think that probably what is going to happen is you have certain rights. If you shift within, the one thing that I can think of is that you would have certain rights under the UCC if it was shipped within, say, 20 days. The customer could give you notice and say that I'm insolvent, and you'd exercise your rights under the UCC to say that you're insolvent and that I'm entitled to the return of my product. And you might be able to claim that gives you a secured or priority position, but that's fairly suspect.
This is an existing secured creditor.
Oh, it's already a secured creditor?
Yeah.
Well, if it's already a secured creditor, then it's already got a security interest on the product that's being returned.
Yeah.
Then when you work your way through the rest of what you've got a potential preference, but you've also got a defense, because the other part of the preference is that the transfer has to result in the creditor receiving more than it would receive if the transfer wasn't made and it got a distribution in Chapter 7. Well, for the secured creditor has first rights on all of that inventory and value. So for a secured creditor, there's not a preference because it's not getting any more than it would receive in a Chapter 7 liquidation. So if you've got a secured relationship and you're already perfected and you're just taking back inventory in which you have a perfected security interest, then you're safe. Okay? But you recognize, the important thing is you recognize the potential preference, but then you've gone to the next step, so basically got a defense to it.
Okay? What about if you foreclose on an IP secured claim, and you essentially have the owner of the IP assigned the intellectual property to you because they defaulted on the loan payment several months over.
Right.
And then within 90 days, the IP owner, so they've assigned the IP based on the secured, and the IP owner, now no longer known, just an assignee, goes into bankruptcy within 90 days.
Okay, but if we've got a situation, again, going back to the issue, okay, we recognize the potential preference, but if you're foreclosing and there's an assignment, you had a secured position beforehand.
Right.
What we really measure the 90 days from is the day that you were duly perfected in the collateral that you're foreclosing on. So if on January 1, I take a security interest in the intellectual property, I take the security interest and I get it perfected. All that happens on January 1. And I'm not an insider. I foreclose after, let's just be safe, make sure we're well beyond our 90 days, and I foreclose on April 15th. Then I don't have a preference problem. I may have another problem, the other kind of avoidance action, which is the fraudulent conveyance.
Okay.
That's what we've got to do. That's what I'm going to talk about next. So the other kind of transaction is a fraudulent conveyance. And what are the basic requirements for a fraudulent conveyance? It is either a transfer of property or the assumption of an obligation for less than reasonably equivalent value made while insolvent or the renders the debtor insolvent. So the key there is again, think about all the issues we have about what constitutes transfer or an assumption of an obligation. That's where we have something additional from a preference. It can either be the transfer of the property or the assumption of taking on an obligation for less than reasonably equivalent value.
So if the loan for which the patent, let's say, was the collateral, was $10,000, and essentially the obligation is, if I don't pay you $10,000 by X date, then I will sell you my patent for that value, for the same $10,000.
Right.
But the patent on the market may be $200,000.
That's the issue. Is that clearly we know what the debt is, but what are we getting in exchange? If it's that clear that the patent is worth $200,000, you're paying $10,000 for $200,000. You're not going to satisfy the reasonably equivalent consideration, and so you're going to have a fraudulent conveyance.
Okay, and so what is the risk to the party that has foreclosed on that collateral for a fraudulent conveyance?
That it will be undone.
It will just be undone in
Well,
due time?
Well, it will be, it's the same thing with the preference. It's either give me back the property or give me the value. And typically what happens is it's relatively rare that a trustee will come back and say, give me back the property. The trustee likes to argue about value and pump up the value and say that, the value is, you're saying that patent was worth $100,000. So maybe I'll give you $90,000. The trustee is going to be the one that says, no, it's worth $200,000, so give me $190,000.
If I just say I'll sell you back the patent for $10,000?
That's not your choice. That's the choice. It's the trustee's choice as to whether they seek the property or the value of the property. So that's your risk. Okay. So and obviously the reason why we want to identify fraudulent conveyance is the same as preference, is that just identify the risk and advise the client as to the risk. Number two, structure the transaction, restructure the transaction, see if we can avoid that fraudulent conveyance risk. And I'll tell you what we can get into is that, gee, where do you get a lot of fraudulent conveyance issues? You get fraudulent conveyance issues when you have corporate family structures with parents and subsidiaries, and you have guarantees or transfer of funds or taking on, assuming liabilities at the subsidiary level for parent debt, sometimes for a sister corporation becoming liable for the liable for the debt incurred by either the parent or another sister corporation. You get into a lot of, gee, all of a sudden I'm giving a guarantee, I'm assuming an obligation that triggers, our first prong of a fraudulent conveyance. Or I'm giving a guarantee and I'm giving a secured guarantee, so I'm also encumbering my assets. So you've got two. You've got both the assumption of a liability and the transfer of an interest because you're giving a secured interest. Then the question is, am I giving reasonably equivalent value for that, what I'm giving up? Well, then it becomes a question of what value is the subsidiary getting for encumbering its assets or taking on assuming that liability. If all the money is going to a sister corporation, or all the benefit of, say, a loan is going to the parent corporation or a sister corporation, if you can't track it down and say that there's a benefit, a reasonably equivalent value or benefit that's being realized by the subsidiary that's giving the guarantee, you've got potential fraudulent conveyance.
How do you make a determination if something is reasonably equivalent in value? Is it somehow related to fair market value or fair value?
That's kind of an open issue as to what it is, and that's where there's a lot of flux in play. I mean, it doesn't have to be exactly dollar for dollar, and you don't have there are both clear, cash in the bank value, and then there's other value. So going back to my example of, say, that a subsidiary guaranteeing a loan to the parent, well, the fact that you don't have to show that it goes up to the parent and then comes down to the sub. You can argue that there's a lot of benefit to the parent that the parent is able to give to the sub short of just actual cash. So because that becomes a very fluid and flexible and often litigious point. Very case specific, and there's a lot that can qualify as consideration. It doesn't have to be cash, but there's a recent case. I'm not sure if you've heard of it, but the TUSA case, TOUSEA, which was essentially, to simplify the fact pattern, that's what happened is that a solvent sub took on the liability for a restructuring that was basically the restructuring parent liability, and it got a lot of press because it was $1 billion. It was $1 billion plus, and after a huge trial, that the court ruled that in fact there wasn't reasonably equivalent consideration, so that the lenders, and I think they weren't bondholders, they were actually lenders. Their interest in solvent sub was avoided. So that's kind of my intro in terms of the things that you have to know. The rest of what I'd like to do is kind of go on to the pitfalls of transactions and deal with various structures that raise bankruptcy concerns. And there's no way that we're actually going to go through all of them. But what I thought I'd do is see if there's an interest. On page 2, there are the pitfalls of various structures that I've identified, and there are a lot. So there's 10. I thought I'd ask if there's a particular interest that any one of them that strikes you as saying, gee, this is particularly relevant to me. I'd like to kind of go look at that. If not, I typically talk about, I start with the asset purchase with the assumption of liabilities as consideration, because that's a fairly common, structure for an asset purchase, and a lot of people don't realize the bankruptcy implications and the bankruptcy risk that it entails, and they kind of they take it on and they don't even realize it, and they're surprised when it comes back and bites them. So, any questions?
What about number 5, the local secured bridge loan? I mean, we had that. What were we doing?
Okay, this is
Right, that's right.
this is actually one of my favorites because there was a point in time as companies, you go through the rounds and there's we're past the point of equity rounds and we're into not just debt, but we're into secured debt, and we've got the VC. And typical venture capital thought is that, gee, I've got to return any investments that I make investments with the potential for a multiple X return. Yeah, that's what the equity game is about, and that's what I like. Whether I'm doing it as debt or I'm doing it as equity, I'm looking for that kind of return, or else why would I do it? I put my money in another investment where I would indeed, it would be an equity investment, I would still be looking for 10X. So if I'm going to put it in as a bridge loan, why don't I get 5X on return? And the issue is, okay, think about it. Let's go back to when we're dealing with structure, transactional structures. We've got two typical risks that we're on the lookout for. We're on the lookout for preference, or we're on the lookout for fraudulent conveyance. Any guess as to which one it might be, or why? We've already talked about it on the foreclosure. If you have a foreclosure and you're owed $10,000, and you're foreclosing on a patent that is worth $100,000. I've said, where's the reasonably equivalent value? Same issue. If your venture capitalist is going in and saying, okay, I'll fund it, I'll put in a bridge loan of $1 million, but I want a 5X return on it. I want $5 million back. Why is that reasonably equivalent? That's getting back $5 million for $1 million. There isn't a court in the United States that will tell you that that's not reasonably that's reasonably equivalent value. They'll say it isn't.
But does jumping ahead of other secured creditors, is that legitimate? Because that's sort of a soft value, not just a dollar number.
Well, the question is how are you going to jump in front of other secured creditors? Number one, that requires the consent of those other creditors. But if we're talking about, let's say we're talking about, let's put aside the issue of the 5X return and say that we're just dealing with we want to do a bridge loan, and our investors are saying, well, I'm not going to put it in as unsecured. I'm certainly not put it in equity, and I'm not going to put it in as unsecured debt. I need collateral, and there is no other there's no other secured creditor. So give me a security interest on my for my $1 million investment. Is there anything wrong with that? No. It becomes a problem where it's give me security interest in the assets and give me an equity-like return of 5X or 3X. And the question is gee, where does, again, how do we define reasonably equivalent value? Can I have kind of extraordinary interest rates? Can I have a bunch of warrant and equity kickers on it? Probably yes. Certainly, warranty and things like that. Could I do a 2X return and say that that is, in this distressed environment, that's reasonably equivalent? 2X, probably not. Not even 2X, I would say. But if I had a fairly generous or extraordinary rate of interest, I think I could easily get away with that. And that would be reasonably equivalent. So, and again, don't think of putting it in as 2X, but you can. There's going to be a certain limit of how much we can give. But we can structure it that it doesn't look quite so unreasonable. and it looks like it could be reasonably equivalent value. And I typically say, look, you're going to have to do something and take your, take a balance of it in warrants. And VC is going to say at that point, but the warrants are valueless. Then you go, well, okay, but that may be true, but there's only so much we can do. We can give you interest, we can give you security, but we really can't say that we're going to give you 5 times your money and expect the bankruptcy court to say that that's reasonably equivalent, whether you're distressed or not.
Can we jump to number 9,
Bringing license, yes.
So a lot of software license agreements contain essentially a source code release provision from the licensor if the software is a critical piece for the licensee, the customer. They contain essentially a source code release and license that springs when the licensor goes bankrupt.
Right.
Or is not able to support the software because it's not bankrupt. So this says licenses to spring into place and become effective, and it might be void under ipso facto provisions. Usually there's also, the Section 365N reservation of rights by the licensee. So I guess I'm not, are you saying in pitfall number 9 that a source code license that springs upon a bankruptcy of the licensor would not be valid? Or?
Correct. Let's just take a step back. Because we're not dealing, this is a risk, this is not a preference risk. This is not a fraudulent conveyance risk. This is our other risk about, this is another risk about really executory contracts and what can happen to executory contracts in bankruptcy. And the general rule is that for executory contracts, the trustee or the debtor, in this case the debtor in possession, has the option to either assume them and take them on or reject them and say that these are burdensome, I'm not going to perform these, and you just have a damages claim. And in the context of IP licenses, that has been deemed, generally been deemed to say that, number one, the IP license is an executory contract, and the consequence of rejecting it is that the debtor rejects and doesn't have to perform the basic license itself. So the license is abrogated. Now there are special protections that were added because of that. That's the way that it was deemed that the effect of rejection. And Section 365, it says that the licensee, the non-debtor licensee, has a right to retain rights. The issue is though, that those Section 365N rights and the ability to retain rights, you can only retain rights as they exist as of the moment of the petition. So you have a contract, you have this relationship, and it has within it, it says that in the event of a bankruptcy filing, my license, I have a license to do X. As of the point of the petition, you don't, the licensee does not have that right. It's not a vested right. And so what will happen is the bankruptcy will cut off that right. If it's not vested at the point of the bankruptcy, it's not part of your Section 365N rights.
Okay, so I'm a licensee.
Let me just, there's structurally a way around that. The way you have to do it is you have to have a present grant of a license, but as long as the debtor is not in default of the arrangement, you agree to forbear from exercising the rights. And that when they default, the forbearance goes away, and then the license is in place. But you have to have the vested license right itself really before bankruptcy occurs, or you never have it.
So the present license grant,
Okay.
that's typically done. But then the additional step that needs to happen before these escrow agents can release the source code and let the licensee essentially exercise the right to support or maintain the software, which is usually when the licensor or the debtor is no longer able to support and maintain.
Right. And as long as you have the right, then the escrows are fine. But there has to be the present vested license before you can have access to the source, to the source code. But there are, as long as you've got the right and the vested license, the other provisions of Section 365N basically say whether you have an escrow or not. If you have an escrow, you're entitled to get the escrowed materials from the escrow agent as long as the debt is in default. Even if you don't have an escrow arrangement and you just have, the obligation to provide me the source code when you go into default so I can support it myself, or go somewhere else and get support. You don't even have to have an escrow. You're entitled to make demand directly on the trustee or the debtor in possession and have them turn it over. The issue is that for good reasons,
sure,
you want to have the escrow. You want an escrow anyway, so you know where it is.
Right. But the main thing is the licensee cannot exercise even the present license grant unless the licensor or debtor is no longer actually providing the support and maintenance for which the license has been released.
Right. Now, and that's the important thing is, I talked about you have to have the license and you have to have a forbearance and you have to have the trigger for the forbearance to go away. We've got the trigger for the forbearance to go away has to be performance related. It can't, for the reasons we talked about before, because of the ipso facto issue. You can't say, I get access, my forbearance goes away because you filed bankruptcy or because of your financial condition. Those are ipso facto clauses. They get ignored and they're not enforceable. But if I say that the forbearance goes away when you fail to respond to a maintenance request or support request, those you get those performance-related triggers, and those are enforceable. And so that's the way you play it out. And I've dealt with that, the 365N for 1980. It's got to be about 20 years. I've always recommended that you actually have the present grant, and it's worked its way in. A lot of people now have that present grant.
They hereby grant, the license is all granted.
Yeah.
But I have seen a few contracts where they just have it's triggered when the company goes bankrupt, as opposed to it's triggered when the company fails to provide support and maintenance when the company goes bankrupt.
Right. And that's still a problem. It's got the risk that you'll never be able to pull that trigger because it's an ipso facto clause and the trigger will go away. How you doing?
Good. Can you describe the hoops you have to jump through, the licensee has to jump through in terms of drafting the agreements so that they'll be able to, they'll have a new license post-bankruptcy. Has that been tested yet?
Hasn't been tested yet. I've certainly had cases where where we put those in there and the company has gone bankrupt. I don't think it's been challenged. That's the problem. It's worked because it hasn't been challenged. What we do know is what has clearly been tested and is known that is not effective is the springing license. There are cases where the springing license has been, they've said, sorry, that's not part of your rights, and you have the license.
The court hasn't said that if you had done it.
No.
Yeah.
No, and that will be, someone will have, in the most part, as long as it's working, you don't get, if everybody recognizes that it works, you don't have a case, that says that it works. You have to have somebody that challenges it. And quite frankly, I haven't seen the case where the structure, the present license with the forbearance has actually been challenged.
But why wouldn't some trustee challenge that with the downside?
Well, good question. There's got to be enough money. I just haven't seen it yet. Questions?
Well, you know, with that, we're at 1 o'clock, so I think what I'll do is close the recorded portion of the webinar. I'd like to thank you, Patrick, for coming over. Before we sign off, the slides are going to be available online on Royce University as well as a recording of this webinar. But if somebody wants to reach you or talk to you further, how do they get a hold of you?
You can, my email is pcostello@Vectus Law Group. My telephone number is 650-320-1688. And you can always go to my website where I have some materials like this and related materials, which is vectuslawgroup.com.
Okay, thanks.